key pronouncement of the last week. First, we are going to discuss apex court decision, and that is very important to many of us, and this is related to provisional attachment. So, friends, just to give the brief background, तो राधा कृष्ण इंडस्ट्री ने ऑनरेबल हाई कोर्ट में रीट फाइल किया, एंड दैट रीट इज विथ रिस्पेक्ट टू ऑर्डर ऑफ प्रोविजनल अटैचमेंट. But High Court has rejected the writ on the basis that the alternate remedy is available to the Radhakrishna Industries. They can appeal to the higher forum. Now, the issue before Supreme Court, there were two issues before the Supreme Court. First, whether writ, whatever filed before a High Court, was maintainable under Article 226. So it was maintainable. And second question of law, or the interpretation question, was whether the order of provisional attachment constitute a valid order or valid exercise of power by the authorities. So these questions were before other authorities. We will see the observations of the Honorable Apex Court for one by one. So first we will discuss about the validity of the writ before the High Court. So while discussing the validity of the writ before the Honorable High Court, Apex Court has held that as per Article 226, so Article 226 आप Constitution का रेफर करेंगे, that Article 226 is with respect to writ. So as far as Article 226 of the Constitution is concerned, the Honorable High Court can issue the writ or can exercise the power of the writ not only for the enforcement of the fundamental right, but also for other purpose as well. That means, like in the fundamental rights, even though there is an alternate remedy with the taxpayer, the writ can be filed. In that case, such a can be used in other cases also. Second key observation, that if the right is created by the statute itself, then resort must have to be given first the statutory remedy, or statutory remedy first is required to be considered before the discretionary remedy. So the court has to consider the statutory remedy first. Second, if this decision is looked after, the order of provisional assessment has issued by the Joint Commissioner. So Commissioner has delegated the power to the Joint Commissioner for the provisional attachment. So in this regard, the Apex Court has observed that the Joint Commissioner, while ordering the provisional attachment, has acted under Section 83 because the Commissioner has delegated the power in pursuance of Section 83, and because of that, whatever the appeal or whatever the provisional order is deemed to be issued by the Commissioner only, and the appeal against the order can be filed only with the tribunal. So this is again a key observation. That means if there is a delegation power, the other person is acting on behalf of the power of the delegating authorities. So who had delegated the power. So this again major key observation of the Supreme Court in this regards, and hence the writ was maintainable at the High Court. Writ was maintainable as per the High Court under Article 226 of the Constitution. Now, key observations. So second part or second issue before Supreme Court was whether about the validity of the order. That means whatever order issued by the Joint Commissioner was valid from the provisions, or the valid with respect to provisions under the Act. So in this regards, Supreme Court observed that the order of provisional, again in many cases we have seen provisional bank account is getting attached even in genuine cases. तो कहीं कहीं जगह पे हमने देखा है कि अपील का समय भी नहीं दे रहे हैं, तो प्रोविजनल अटैचमेंट, फॉर एग्जांपल रिटर्न अगर आपने पेमेंट 3B का पेमेंट नहीं किया तो प्रोविजनल अटैचमेंट हो जाते हैं बैंक की. इवन 2 days आर नॉट गिवन फॉर द 3B पेमेंट्स in one or two clients we had seen. So they had attached the bank account even without giving the personal hearing. We found that the bank getting attached. So friends, these observations are very much useful. So as far as Honorable Apex Court has said that the power of provisional attachment entrusted, or the power of provisional attachment can be used only during the pendency of the proceeding under the prescribed section. So if you see the section 83, that section says that the only for the, if there is a pending proceeding under section 62, 63, 64, 67, 73 and 74, then only the power of provisional attachment can be used. Second, and key important fact is that the commissioner must be of the opinion that for the purpose of protecting the interest of the government revenue, it is necessary to do the provisional attachment. So it should be the sanction from the commissioner, and second, there should be the opinion from the commissioner that is it is necessary. So Apex Court has also defined the term necessary. Only in the exceptional scenario the provisional attachment can be made wherever the commissioner has doubt, or the wherever the commissioner has a doubt that they're needed, or there is a necessary for to attach the property, because the for protecting the interest of the revenue. Second, this order must be in writing. So order should be given in writing. And as per the all the rules or all the procedure of the rule 159 should be followed. As far as rule 159 5, if you see, there is a two requirements or mandatory requirement in case of provisional attachment. First, it is entitled to submit the objection. So the objection can be submitted, or the taxpayer is entitled to submit the objection on the ground that the property was attached is not liable to be attached. So that should be the compulsory or mandatory requirement. And second, the hearing is the mandatory requirement. So before provisional attachment, opportunity of being heard is required to be given. So in many cases, we had seen the provisional attachment has made even without giving an opportunity of the hearing. So that is a mandatory requirement as far as Rule 159(5) is concerned. Second, once appeal has been filed by the taxpayer, then the proceedings under section 74 no longer is pending. That means once appeal get filed, then the provisional attachment is required to be removed, because then it is said that the whatever the proceedings under section 74 is not now no longer pending. And the order of provisional attachment of the property, including the bank account. So bank account should be the last recourse. So lastly, the bank account should be because it would affect the businesses. So these are the very key observations of the Apex Court decision, and can be used going forward whenever there is an provisional attachment by the authorities without any reason in genuine cases. So this observation will definitely help to the taxpayer. So while deciding the case, Apex Court has held that the writ petition filed by the appellant under Article 226 of the Constitution shall stand allowed. So it should maintainable appeal, maintainable writ, and by setting aside the order of provisional attachment is also required to be set aside, because it is not as per the GST Act. So friends, these are the definitely key observations. However, we intend to, or as a firm, we intend to highlight some of the key points with respect to decision, or which is related to decision. तो फ्रेंड्स, आपको पता ही रहेगा कि बजट 2021 में, सो रिसेंटली सेक्शन 83 हैज अमेंडेड, एंड सेक्शन 83 वन अमेंडेड टू वाइडन द स्कोप ऑफ द सेक्शन 83. तो पहले जैसे अपेक्स कोर्ट ने बोला कि ओनली इफ देयर इज अ पेंडिंग प्रोसीडिंग अंडर द स्पेसिफाइड सेक्शन, और वो सेक्शन थे सेक्शन 62, 63, 64, 67, 73 एंड 74, द ऑर्डर ऑफ प्रोविजनल अटैचमेंट कैन बी इशूड. बट अभी जो अमेंडेड सेक्शन है वो सेक्शन वाइडर है. सो प्रपोज्ड सेक्शन, एज पर प्रपोज्ड सेक्शन, नाउ the proceedings can be or order of provisional attachment can be considered if there is a pending proceedings under chapter 12, under chapter 14, and under chapter 15. That means they had now, as far as amended provision or proposed provisions of the budget 21 concern, there is a wider scope of the provisional attachment, but even the scope is widened, the apex court ruling is relevant for us because the amended provision has also be implemented only if there is a commissioner opinion that it is essential or it is necessary to do so for protecting the interests of the government revenue. So commissioner should be of the opinion before provisional attachment. Second, the fact that the regarding the bank account should be the last recourse. So the rule 159 required to be followed, like the order should be in writing, then the order should be given an opportunity of personal hearing.